is Annie Thompson. I am the Chief Claims Officer at Lawyers Mutual Insurance Company, and I have the pleasure today of introducing your main speaker, Erin Joyce, who is a friend and a colleague and a premier ethics expert in the state of California. She has extensive experience in state bar investigations and disciplinary proceedings, plus over 25 years in civil litigation practice. She was admitted in 1990 and practiced for nearly 8 years in an intellectual property boutique before joining the Office of Chief Trial Counsel as a prosecutor for the state bar from 1997 through 2016. Erin has over 20 years experience in handling all aspects of discipline cases against attorneys in state bar court, from the filing of the complaint through trial and review. She's personally tried dozens of state bar trials and several appeals. Erin has a comprehensive understanding of how state bar investigations and appeals and proceedings unfold. Before going into private practice, Erin served as Chief Special Investigator for the Los Angeles Fire Department, as a prosecutor for the State Bar of California, and as a lawyer for multiple private practices. So you are in good hands today in understanding the rules of professional conduct in the wake of the recent wildfires. I have also been invited today to let you know that Lawyers Mutual is a sponsor of your on-demand platform and share with you a little bit about our lawyer-to-lawyer hotline, which is available to our members and will serve as sort of a triage ethics hotline if you find yourself in situations that you believe may give you some ethical pause. Call our lawyer-to-lawyer hotline so that you don't end up having to retain Erin Joyce later after the state bar has begun to investigate you. We will walk you through the ethical conundrums you may face and answer any questions prior to picking up representation to see if this is the right fit for you and whether or not you are in any danger of state bar repercussions. So dropped in the link will be some information about how to get additional details on that if you are a member or if you are a non-member interested in that service. Additionally, I will remain on this seminar to join Erin for any Q&A that you have for either of us about any of these issues. And with that, let's get started. And I present to you the esteemed Erin Joyce.
Thank you so much, Annie, and I appreciate being able to speak with you this afternoon about, we're talking about in the wake of the recent wildfires in Eaton, Altadena, and the Palisades, and most specifically, potential advertising and solicitation problems which may have you may be facing. Now, I'm sure all of you lived through January and basically the fires and all the winds and et cetera, and the extensive damage both in Palisades and Altadena. I myself was sitting in my office here in Pasadena on, I think, Tuesday, and literally I was speaking to one of my clients that morning who told me he was distracted because about 5 hours before that, he had gotten a call to evacuate his apartment building over on La Cienega or around there near Palisades, and he never got a chance to take anything out and his entire building went down. But that evening, as I was driving along the 210, I looked north and I'm like, wait, I thought the Palisades were on fire. But that was the glow of the Eaton fire and the majority of Altadena going up in flames. So you all lived through it here in Southern California. And what ended up happening, or it's happening now, is that with the extensive property damage, from both fires, there has been a swell of attorney advertising and solicitation of those potential prospective clients who may have either insurance issues, bad faith cases against their own carriers, or especially with respect to the Altadena Eaton fire, potential third-party claims against Southern California Edison and others that may be responsible for that fire. The Attorney General Bonta put out a statement at the beginning of April, and he said, basically, that he encourages lawyers practicing in California to familiarize themselves with the laws governing client solicitation after a national disaster or catastrophe. And given the great collective damage in the Los Angeles fires, attorneys need to ensure that they're practicing ethically and in compliance with the law. So the main points raised in the statement from April 1st were, the public in general, but lawyers should be reminded that California law prohibits lawyers from soliciting clients by in-person or by telephone or real-time electronic contact. Also, soliciting clients that have already made their desire known not to reach out to them, or any kind of solicitation which makes that's either intrusive, involves coercion, duress, or harassment. Now, mailed communications are allowed. However, you have to be really careful and make sure that they comply with the rules and that they're not either false or misleading. And then sending recorded or electronic communications have to be identified as an advertisement as well. And I think one thing that's really important to know is that California, just like in many other areas, the rules with respect to advertising and solicitation are significantly different than the model rules promulgated by the ABA, and which most other states follow something more akin to the model rules. We're the only state, and we're going to get into this. Yes, we all understand what in-person solicitation is. That's like knocking on the doors. That's actual ambulance chasers at the emergency rooms. That's the typical look. Telephone, that should be pretty easy. That's phone calls. But real-time electronic contact, that is something that is unique in California, and we're going to talk about that a little bit later. And what does that mean? Now, in addition to the Attorney General, making a statement at the beginning of April, there are moves within Sacramento, both in the Assembly and the Senate, to address what is seen as this groundswell of legal advertising aimed at the victims of both the Eaton and the Palisades fire. And let's take a look at the first one. The first one is SB 37. This is a proposed new, and these proposals, I want to be really clear, they're not at this point adopted. They're making their way through the Byzantine structure in Sacramento. We don't know if one or either of these different approaches that are currently being considered are going to make it through. I can say I don't want to say certainty, but with some sense of that actually this might happen, that the state bar, unlike in most areas, the state bar also is interested in attorney advertising more than in generally, because of the high profile nature of the large amount of solicitation and advertising related to these fires. So even irrespective of these proposed new legislation and legislative answers to deal with what is seen as a problem, basically all these fire victims being besieged by attorney advertising and direct solicitations, there already are existing statutes and rules of professional conduct which do govern this area and may be implemented if there are problems. So let's take a look at the first of these new proposals, SB 37. The first factor I want to look at here is it proposes a private cause of action for capping under Business and Professions Code 6152. It's already in a legal act in California to engage in capping. And capping, for those that don't know, I'm so sorry. I went back. I think I'm here, so sorry. Capping is basically the classic ambulance chasing. It's basically having mostly non-attorneys go out and find clients and either pay clients or pay people to bring in clients. That is already illegal under Business and Professions Code 6152. But the proposed SB 37 would create a new cause of action for capping under Business and Professions Code 6153, and it would authorize statutory damages of up to $100,000 per violation and attorney's fees and injunctive relief. So this isn't the law, this is a proposal, but this would certainly change the landscape on attorney solicitation and advertising, should that be adopted. I have been doing ethics cases and state bar cases for decades. I have seen almost no cases that are involved solely in capping. There are some significant state bar discipline cases that capping has played a part. Generally, that also includes unauthorized practice of law, etc. But it's not something that the state bar spends a lot of resources pursuing and prosecuting. This type of a change would maybe change that landscape, as I said. Another part of the new SB 37 that's under consideration is creating a new cause of action about running an improper lawyer referral service, or LRS. There already is existing legislative structure for registered lawyer referral services. But generally speaking, the lawyer referral services that operate in California are operated by the different various local bar associations. But there are unregistered lawyer referral services or websites that act as lawyer referral services that do not comply with the requirements of Business and Professions Code 6155. And this proposed legislation would authorize private causes of action for violating the LRS statute and again, provide for significant statutory damages up to $100,000 per violation, allow injunctive relief and attorney's fees. So it puts teeth in both the LRS statute for requiring registered lawyer referral services and also teeth to prohibit capping. Now, what's really important about SB 37 is that these remedies will be allowed to proceed without the action of the State Bar of California. So right now, for many reasons, not to be discussed here in particular, the State Bar has devoted very limited resources to policing lawyer referral services at all and capping almost at all, unless it's open and notorious with a lot of other types of violations by those attorneys being prosecuted. So allowing private citizens or lawyers that are seeing their competitors, rampantly engaging in basically paying per lead or other type of capping activities will now have another tool in their arsenal to stop this kind of conduct, which is already illegal. There already is a legislative scheme for what it takes to become a registered lawyer referral service. And there are also criminal and other prohibitions against capping. It's just that the State Bar and other authorities haven't done much to enforce those rules. So this SB 37 would give another way to get these rules and statutes give them teeth. Now, another part of the proposed legislation is to strengthen the attorney advertising rules. There already is on the books, basically, it's going to strengthen the obligation about restrictions on lawyer advertising. So the new section 6157 would have a different, much more precise definition of what it means to have advertise or advertisement. And then it'll be any communication through any written, recorded, or electronic means, whether available to or directed or generally to members of the public or a limited group of individuals that provides information concerning a lawyer or the lawyer's services for the purposes of engaging individuals to secure the services of the lawyer or the firm. So it's a much more precise definition. Now, more changes being considered would be prohibiting, we already have Rule of Professional Conduct 7.1, which we're going to touch on a little bit later, which provides that lawyer communications can't be false or misleading. But the proposed 6157.2 of the State Bar Act would prohibit misleading, deceptive, or false statements, words, or phrases regarding a lawyer's law firm skills, experience, or record. I have seen some cases which touch on a violation of Rule 7.1 when attorneys put on their website information about their background, which is not merely puffing, but misstates or misrepresents their experience. A really classic example of that would be when someone says, 25 jury trials, But in fact, the real truth is they were second chair at like 25 jury trials, and they've never done a jury trial on their own. Without more information, that type of representation on the website would probably already violate Rule 7.1. But this proposed change in 6157.2 would make that type of misrepresentation have more potential downside. You'd also require that advertisements state the location and address of record listed with the state bar for the lawyer or the law firm. Right now, we're going to see this more in particular what the rules are now, you have to have at least one attorney identified on any lawyer advertisement and an address. But in today's digital world, what does address mean? Address probably doesn't mean a street address. Probably, under the current rules, it's sufficient to have a link to your website that has addresses and email addresses and contact information. But this would make it more particularized that the address of record with the State Bar of California would have to be identified on advertising. And I think probably what's really important here is if this legislation is adopted, it would create a private cause of action for a consumer misled by an advertisement and not just for a person. Because right now, the attorney advertising statutes don't allow for a private cause of action for any consumers that may have been misled. So this will open up potential areas of litigation concerning legal advertising. And I think that's what the point of this is, obviously. So now there's in the assembly, there's a different approach being considered to tackle what is identified as a problem arising from the recent fires. And that is, again, this groundswell of a major advertising from both in-state and out-of-state lawyers. So here, violations of the attorney advertising rules would be able to be prosecuted by consumers as unfair competition or false advertising. So as a Business and Professions Code 17200 or under 717536 of the Business and Professions Code. Now, also, AB 931 would prohibit fee splitting between a California lawyer and an out-of-state ABS or alternate business structure. Right now, there's just a handful of states which allow alternate business structures, most notably Arizona. And we can see what's happening in Arizona. A lot of the personal injury or mass tort firms are consolidating as a result of the ABS adoption. So this AB 931 would prohibit California lawyers from sharing fees with an ABS out of Arizona or anywhere else. It also authorizes statutory damages and attorney's fees and injunctive relief, and it does provide another basis for state bar discipline. But frankly, most of the time, the state bar doesn't pursue standalone false advertising cases. We'll see a couple of the very notable examples, of which there are very few. Again, the resources of the bar haven't been directed at advertising issues. But because this is now in the news, there's I would imagine that there's more likelihood of going forward that will change. The AB 931 also is very ambitious. It's taking on the problem with legal funding. It would prohibit litigation finance companies from paying any consideration for referrals from attorneys. It would prohibit them from making referrals to any attorney in the furtherance of legal funding. So in the situation where you see, hey, you can get you money up front on this case if you go with this lawyer, that type of conduct would be prohibited. And also, they would only be able to, that a litigation finance company or a litigation funding loan company would only be able to make referrals to a registered lawyer referral service, one that's operating with a basically registration with the state bar under Business and Professions Code 6155. We don't know how that, two different approaches, both one in the Senate, one in the Assembly, is going to pan out. Maybe neither one of them will be adopted. But one thing we can say is that attorney advertising and solicitation is front and center now, probably because of the recent natural disasters have created so much more advertising in this area and more uproar with all these people displaced from their homes and then constantly getting mail about like lawyers looking to capitalize on helping them recover from their injuries, or even like real estate agents trying to get them to sell their now vacant lots for really inexpensive. So the seminal case, now you might say, okay, can the state bar, does the state of California have a right to legislate or regulate attorney advertising? And that was not even a question at all up until the mid to late 1970s. Bar associations regularly prohibited any kind of advertising by lawyers. Because in one way, you can consider it protecting the guild and the professionalism of the profession. The whole argument, is it a business, is it a profession, still was up in the air. But in 1977, in Bates versus Arizona State Bar, the Supreme Court found that, yes, even lawyers have First Amendment rights, basically. That, yes, the state and the state bar can, and in order to protect the public, has an inherent right to prohibit false or misleading type of advertising. But generally speaking, allowing lawyers to advertise fosters the idea of access to justice. It gives consumers and potential clients more opportunities. So instead of protecting the guild and the profession, the basis is to allow the free market of ideas in advertising to allow clients to get the best legal services at the lowest cost. Now, okay, urgent legal needs and demands coupled with unethical advertising and retention practices obviously could lead to potential ethical pitfalls and state bar complaints and potential discipline. And I myself have done consultations with respect to what are the outlying limits with respect to solicitation or even advertising with many of my clients. And the one thing I would say is that how do these kind of cases get to the state bar in the first place? Most of these kind of cases are not cases that come in the typical course of action, which is, a client says, a typical bar complaint would be from a client, and a client that says my lawyer either didn't return phone calls or didn't work well on my case, or both. These kind of complaints don't generally emanate from a client, or at least a happy client. Most of advertising kind of complaints come from a competitor, someone that's chasing the same business as the lawyer who's being accused of, cutting corners or making active misrepresentations in either advertising or improperly soliciting prospective clients. Because even though, yes, there's 9,000, 10,000 structures that burned in the Eaton fire and a huge number of victims in the Palisades fire, there still is a limited number of prospects, and they're getting solicited by many different sources all the time. So these type of complaints come to the attention of the state bar, usually by a competitor who's trying to bring to the attention of their licensing authority another lawyer who's not following the rules. So it's very important to, especially when there's incredible scrutiny on all the legal advertising in every different media that's going to be generated, result looking for those same prospective clients who were injured in these fires, to ensure that these are proper and appropriate type of solicitations and or advertising, because you have so many people that are going to be watching. And those people are going to be happy to report people that aren't following the rules to the state bar. And that's how the state bar gets these cases. They're not out there looking for them on their own. So under Rule 7.1, which deals generally with communication concerning a lawyer's services, a lawyer shall not make a false or misleading communication about the lawyer or the lawyer's services. A communication is false or misleading if it contains a material misrepresentation of law or fact, or it omits a fact necessary to make the communication considered as a whole not materially misleading. So directly false, that should be easy. But what does it mean to be misleading? Now, Rule 7.1 goes on in subsection B to talk about that the Board of Trustees can formulate or adopt standards as to communications presumed to violate, the advertising and solicitation rules, the Chapter 7 series. The standards are to be used as presumptions affecting burden of proof. A presumption, as you all know, means it's basically going to be affecting burden of proof in a disciplinary case. The good news is that there aren't these under the prior rule 1-400, there were really extensive rules even governing the font size on advertising. The Board of Trustees has not adopted those kind of strictures. In fact, in general, I would say with respect to the current rules of professional conduct and in advertising and solicitation in particular, there's been a relaxation of the prior rules, favoring more ways and requirements with respect to attorney communications. Now, what does it mean to be a false or misleading statement? So under Rule 7.1, it is always implicated in attorney communications a general prohibition about making false or misleading communications to anyone in any way, right? Including in advertisement. So that is, I think, a basic fact. A communication is false or misleading where there are misrepresentations of fact or law, or again, it omits something that's necessary to put everything in context. If you think back, I mean, when I was growing up and all of the TV that was surrounding either late afternoon or even like Saturday morning cartoons, I remember the Larry H. Parker commercial he got me $2.1 million. And you saw the complaint, the client from the neck up. You didn't know he's sitting in a wheelchair and he was a quadriplegic or whatever he was. So potentially false or misleading, and also and that's actually a really good example of a problem commercial on a lot of levels. One of them being every single case turns on the facts and circumstances of the individual case. Testimonials are valuable because they have so much of an opportunity to be persuasive. Any testimonial that is used either in a website, in a social media post, or anywhere, if you're using testimonials, they're very powerful. Of course, they have to be true. You can't make up testimonials. I've had cases like that where an attorney's website had a bunch of concocted testimonials and reviews. That obviously is more than just misleading. That's directly false. But if you're going to use even legitimate, true testimonials from really, really happy clients that got a really great result, they really potentially would be misleading because they don't have a disclaimer. So you really need to have a disclaimer if you're using testimonials. Now, when you're talking about being of counsel to a firm, if you look at formal opinion of the State Bar 1986-88, it provides guidance. To avoid a misleading the public, a lawyer or a law firm contemplating listing an out-of-state lawyer or law firm as of counsel or with any other relationship must negate any impression that the firm or lawyer is a California firm or lawyer, that the firm employs licensed and lawyers to practice law in California, or that the firm is available for employment in California when it is not. Appropriate disclosures must be made when listing an out-of-state lawyer on any communication to the clients, either on your letterhead, on advertisements, in an email, or anywhere else. So be very, very careful. If you call yourself a California lawyer, or if you call yourself a lawyer, even on LinkedIn, and you use a California address, you have to be admitted in California. And if instead you're just admitted in Nevada and let's say New York, you have to have an asterisk and say not admitted in California, admitted only in New York and Nevada. Even there are cases that say by saying you're admitted in Nevada and New York, if you don't disclaim the fact that you're not admitted in California, that may not be enough to avoid a perception of being a California lawyer. And under the unauthorized practice of law statutes in California, there's two different aspects of unauthorized practice of law. One is actually practicing law, but the other is holding yourself out as able to practice. So you don't want to be, if you're like, let's say, partnering with an out-of-state law firm to provide legal services related to the fires, you have to be very careful to identify that other law firm. And if they are only entitled to practice out of state, clearly you have to make clear where they are entitled to practice and that they're not entitled to practice in California, if that's true. Now, under formal opinion from COPRAC, which is the State Bar's Ethics Committee, under 1993-129, in order to avoid false, deceptive, or confusing communications, a principal member of a law firm may hold out another member of the firm as of counsel only where their relationship is close, personal, continuous, and regular. So long as that standard is observed, there's no absolute limit to the number of counsel relationships which the member or firm can participate in as of counsel. So this is, another potential advertising type issue, because if you're holding someone out to be of counsel with your firm, you're basically warranting that they have a close, personal, continuous, or regular relationship with your firm. And as I kind of already touched on, if you look at, it's very important, especially in the advertising series. There's the Chapter 7 series of Rules of Professional Conduct. The rules themselves give a lot of guidance, but you really have to read the comments. The comments kind of put the meat on the bones to understand what is meant by the rule. So here, if you look at comment 2 to Rule 7.1, it warns that communications guaranteeing a result are false and misleading. Very, very serious problem if you guarantee results. In fact, you probably should say the opposite, because results are not guaranteed, and each case is going to be based on facts and circumstances of that case. And with respect to your testimonial of your super happy, very, very satisfied client, you say the results are atypical, because you cannot warrant any particular result. Now, comment 3 talks about even truthful statements can be misleading if you can have all of the facts there for a reasonable reader to understand. So the example is no fee without recovery has to be clear. Does that mean no fee without recovery? Does that include litigation costs are going to be waived if there's no recovery, or do you expect the litigation costs to still be paid? Either way is okay, but it has to be laid out. Otherwise, that representation is not going to pass muster. Now, I touched on testimonials earlier, but there's a reason why people use testimonials all the time, because they're very persuasive. They really sway opinion. Case results, endorsements, 5-star reviews, all of those are great. We want those. But comment 4 to Rule 7.1 provides that even a truthful statement can be misleading and a violation if it would lead a reasonable person to form an unjustified expectation that they could obtain the same results. Again, that's why having a disclaimer is so important. Now, if an advertisement or solicitation guarantees a result, it's a presumptive violation. So depending on how you word your website or your advertising, you have to be very careful not to promise the results. And you should only post testimonials with informed consent and ensure it does not create an unjustified expectation to achieve the same result for others. So a lot of attorneys, when at the end of a successful representation, will send out a link so that the person, probably only to people that were happy, would be able to post a review or something on your Google business, etc. Always make sure that the person who's filling out the questionnaire or the review knows that it's likely to be posted or may be posted. Now, I did say earlier on that the State Bar seldom wades into purely advertising cases. And that is absolutely true, because the last big advertising case was In Re Morse from 1995. And this was not a typical advertising case at all. This attorney mailed out millions, 4 million solicitations about homestead. And pretty much he ticked off every box of what you should not have in an advertisement. And Mr. Morse got multiple cease and desist letters before the State Bar Office of Chief Trial Counsel decided to take some action. And that's the first line of defense. When the State Bar does an investigation and determines, during the investigation that there may have been either an improper reach out through, let's say, Facebook Messenger or something, or maybe the advertisement didn't have all the information needed, they will issue what's called a cease and desist letter and then close the case. But if they have to have sent out multiple cease and desist letters and the conduct persists, that's when potentially the State Bar would take some action. So in this case, Mr. Morse, he used government insignia to get the homeowners to open these envelopes. He targeted people who had already gotten a notice about being behind in their mortgages, so they were already susceptible. And he omitted the fact that even without filing this homestead exemption, the homeowner had exactly the same rights that the work that Mr. Morse did provided zero benefit at all to the client. And with all of those facts, he ended up getting actual suspension. So in my experience, if an attorney is approached about their advertising, if they have a good faith explanation of what was going on with that ad, even if there were problems with it, there'll be an opportunity to remediate before the state bar takes action past that investigation stage. That's generally what I've seen. Now let's take a look at, we've now kind of covered 7.1. So let's look at 7.2, which is the attorney advertising rule as it currently exists. Under subpart A, subject to rule 7.1, which prohibits, again, we already looked at that, false or misleading comment, communications from a lawyer, and rule 7.3, which deals with solicitation, a lawyer may advertise services in any written, recorded, or electronic means of communication, including public media. And as you all know, in this new media age, you know, Facebook and Instagram and TikTok are full of attorney type of, you know, infomercials, you know, informational and also potentially advertising. Now, under subpart B, a lawyer shall not compensate, promise, or give anything of value to a person for the purpose of recommending or securing the services of the lawyer or the firm, except, and then there's a bunch of exceptions. The first one, yes, you can pay reasonable costs for advertising. That is permitted. Then you can pay for being part of an LRS. And 3, you can pay by a law practice. Now, in subpart 4, you can refer clients to another lawyer or non-lawyer professional, so long as that is not otherwise prohibited. So you can't share fees with a non-lawyer. That's a violation of Rule 5.4. It's otherwise prohibited. Provided that you have a referral, like a referral arrangement that's reciprocal, so long as that reciprocal referral arrangement is not exclusive, and that the client is informed of the existence and nature of the arrangement. So let's imagine you're an estate planning lawyer and you get a lot of potential family law clients. So if you have one family law lawyer and you say, I'm going to send you all of my family law cases, so long as you send me all of your estate planning prospects, that would violate 7.24 subsection 1. So it's very important in your natural area of referrals to have multiple sources to be able to make referrals to. And the part about the client being informed of the existence and nature of the arrangement, that's why organic referrals work best. Because then you can say with all certainty and honesty, I'm referring to Joe because I know his work. I've come to know, like, and trust Joe because of my networking, and I know his type of work and the quality of his work from I've talked to other happy clients, etc. If there is money being exchanged for the referral between lawyers, which is totally acceptable, no problem at all, as long as you're in full compliance with Rule 1.5.1 of the Rules of Professional Conduct, meaning at the time of the referral, you have to ensure that the client is aware of the referral, the client approves the referral, and that the client is made aware of exactly the nature of how the fees are going to be split, what type of referral fee is going to be paid, and who is sharing the fees, either by law firms or by lawyers. And that type of an agreement has to be signed by the client, the referring attorney, and the referral attorney. All have to have it in writing. It does not need to all be in one document, however. So if your firm has a existing referral arrangement with a particular law firm, you can have that in writing, and then each individual case that is signed up, the client can approve the referral in the engagement agreement. And really that's outside the scope of what we're talking about here, but if you have more questions, we can follow up on that out maybe in the questions. Now, under subpart 5, you can offer or give a gift or gratuity to a person having made a recommendation resulting in your employment, provided the gift or gratuity was not offered or given in consideration or understanding that the gift would be forthcoming or that referrals would be made in the future. So all this is saying is that you cannot have a quid pro quo, like, hey, public adjuster, every time you send me a client that signs me up for his first party bad faith case against his insurance company, I'm going to give you $1,000. That wouldn't work, because that would be either splitting fees under Rule 5.4, or it would certainly be a violation of this rule if you considered it a gift, because it's a quid pro quo for that referral. It's basically buying a lead, which is prohibited by, it's also a capping violation. But absolutely, you can be generous to people that send you business. And unlike under the ABA model rule, there's no proportionality under Rule 7.2, the subset B5. Meaning, if someone sends you a case where you net out $1 million of fees, to thank them, even if they're not a lawyer, you can have like a nice red sports car with a big red bow delivered to their office, as long as it wasn't approved in advance. It's something that, you know, by happy coincidence, you are a generous person and you recognize when people are good to you. Now, under subpart C of 7.2, it says any communication made pursuant to the rule has to include the name and address of at least one lawyer responsible for the content. And as I already said, address in today's digital world probably doesn't require a street address. If you have a link in your TikTok post back to your website, which has all of your contact information, that probably would suffice. Ethics opinions surrounding advertising are behind the times. This technology is you know, growing and becoming more and more sophisticated. In fact, the difference between advertising and solicitation is becoming blurred because of what's available out there to really target your market on advertising. So we don't have advertising ethics opinions that really get into the details about whether or not a link in the address would be enough. But at this point, based on what the technology is available, it's probably going to be sufficient. Now, the rules of professional conduct don't generally, you know, specifically talk about website marketing. And if you look back at a really ancient history, ethics opinion 2001-55, it talks about online advertising. And 2001-55 talks about turning advertising on a website is governed on the same rules as print advertising, like it was in a magazine. So, a website is going to be considered not a solicitation, but a communication. That's probably still sound, that part of this rule. But again, you know, websites are almost required for lawyers, because even if your whole business is based on referral by word of mouth, whoever gets that referral from their trusted source is going to get on the Google and find your website and make sure you're real and make sure that you have credentials. So having a website is pretty important. So at this point, most lawyers don't just have a website. They do a lot of other things to do outreach through even the website and having like a chat bot or at least a question box. So again, a lot of the ethics opinions haven't caught up to this area. Now, under 6155 of the Business and Professions Code, it talks about joint advertising. There's nothing that prohibits lawyers from engaging in joint advertising for their services. You can have that, and when you do that, it has to identify the advertising attorneys who are doing this together, and any certifiable referral activity involves some other person other than the consumer. So it's very important to identify with in cooperative or joint advertising who's involved. Now, if you look at, this is a case on solicitation from the Supreme Court. Now, for-profit solicitation is not entitled to the same degree of constitutional protection as other types of commercial speech, which makes sense. This is a case out of the 11th Circuit here. Basically, you having a ban on in-person solicitation is allowable because, again, you have very susceptible prospects. In our case that we're talking about here, people that lost their homes, maybe every single picture of their father. I've heard a lot of horror stories. I've had people that had home offices. Yes, they had cloud-based files, but they still had original documents that now cannot be retrieved. You know, so these are very susceptible prospects. So in-person solicitation is very dangerous for those. So having a prohibition against direct in-person solicitation, directly like ambulance chasing. Think about it, bringing the engagement agreement into the hospital room. That's prohibited. And what's the reason for prohibiting solicitation? It really does bring the entire profession down in the esteem of the general public. There's so much of a risk for overreaching, overcharging these very susceptible, prospects that are targeted. There's a major risk of misrepresentations in these in-person verbal communications. There's other ways to solicit those potential prospects so that they can get information so that they can make an informed choice about counsel, whether they need it or not, or if they're going to pick any counsel, who they're going to pick. Also, victims of natural disasters or prospects for this type of in-person solicitation, like let's say the family that just lost the kids, or the family or the person who's in the hospital, or in our case, all those people that lost their homes that when they go to their mail drop and pick up their mail have a whole, it's entirely full of lawyer letters. Lawyer letters can be weeded out differently than if they keep getting phone calls or direct, people showing up at their apartment now that they had to rent. And it's very difficult to monitor. So a client can't waive improper solicitation in a fee agreement. So you can't go out there to the hospital and have someone sign off, oh, it's okay, I did this. In fact, not just this, a lawyer cannot have a client waive violations of the rules of professional conduct. That itself is a violation. It's an added violation of overreaching. Now, subpart A of Rule 7.3, I kind of touched on this earlier, but let's highlight it now. It says a lawyer shall not by in-person, live telephone, or real-time electronic contact solicit professional employment when a significant motive for doing so is the lawyer's pecuniary gain. Unless, one, it's another lawyer, because we're immune, or unless the lawyer has a family, close personal, or prior professional relationship with the lawyer. So let's talk about these. In person, knock on the door. We get that. And if they're out of their door because they don't even have their house anymore, it's not that hard. It's a couple clicks of a computer to find out where they rented now, where they're staying now. You can't go in person. That's prohibited. Unless they're, okay, we're going to get to the unless in a minute. Okay, live telephone, that's easy, right? Taking up the phone and making a call. But in today's world, who does that anymore? No, most people text. And here is a real strange anomaly with respect to the California advertising and solicitation rules. Because your same smartphone that gets emails can beep and have an email and can beep and have a text message. An email is analyzed just like it's a direct mail. Just like you sent a mailer out, that's what an email is. An email, and this may have make sense when you think about where email came from. Electronic email really started in offices. It was business communication. So just like every day, if you go through your mail at home, you have all these direct mails, from the grocery store, this and that. There's junk mail. You can weed that out. Email has that same, concept. It's going to be analyzed like it's a direct mailer. You can either, put it in the stack to look at later, or you can just trash it. Click, 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 delete, 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 delete. But live telephone or real-time electronic contact, what does that mean? That is a text message. Now, okay, I'll be very clear. There's no California ethics opinion directly on this point. And really, really ancient ethics, advisories talk about being in a chat room, back, 30 years ago, 25 years ago, chat room as being real-time electronic contact. That is not real-time electronic contact as of 2018 when these rules were adopted. It's text messages. It's also in this brand new area where through your social media posts, you can actually have direct messages, Facebook Messenger. You can have, I think Instagram has that. I'm not on TikTok, but maybe they have that too. There are so many different ways to do real-time electronic contact. So whereas an email is appropriate and allowed if you get someone's email address, a text message to their phone number or finding out their social media handle and getting to them through Facebook Messenger will be prohibited under real-time electronic contact. And this is an advancing area. I mean, the sky's the limit, and someone's imagination that does that kind of work will tell you all the different ways that they're able to like get to you on that same phone at the same and with the same speed. And this may, shake out. But the idea is people pick up their phone, and it rings. They don't have that same ability to like just weed through, click, click, click when they're deleting emails or throwing away the direct mailers when they're going through their mail at the end of the day when they get home. Now, who can you solicit in these ways? In person, live telephone, or real-time electronic contact? That would be a lawyer. So other lawyers were immune. So sending solicitations, making phone calls to other lawyers, totally fine. Anyone that you have a family, and family doesn't probably mean mom and dad and siblings and direct children. Family is a much more broad term than that. It could be even not blood relatives. It could be your spouse's family. It could even be godmother that grew up with you. That would also probably be under close personal. And what does it mean, a close personal relationship? Probably it doesn't mean someone that you went to grade school with and you have not seen since, 1982. That probably is not a close, actually, I'll go out on a limb and say that's not a close personal relationship. But if we met in 1982 and we've been continuously always getting together at Christmas every year when you come back into town, that could be a close personal relationship. Just like most things with lawyers, it's going to turn on the facts. And prior professional relationship clearly involves, for sure, former clients. But is it limited to former clients? Unlikely. Because if you are someone that sits on different professional organizations, both within the law, and maybe you're on the GLAZA board for the zoo, maybe you're on the board at the school, maybe there's other professional relationships other than simply a client. Maybe this is someone that served as an expert witness for you on multiple cases. So that's your prior professional relationship. The idea here is you might have another reason to reach out to these people other than just trying to secure a case. And you know what? If your close personal friend lost their home in the Palisades, you may be calling to offer help more than just to get your own pecuniary gain. So if you have a reason to be checking up in on somebody, that probably means you're going to be okay with respect to this. That it passes that smell test. Like there would be a reason why you would call because you know them and you know their loss. That makes sense. Okay, now under subpart B, a lawyer shall not solicit professional employment by a written, recorded, or electronic communication or by in-person, telephone, or real-time electronic contact when not otherwise prohibited if they've already told you stop. I don't want to get any more of these. You can't keep at it. And then also you can't use the other kind of means like even a direct mailer if it involves intrusion, coercion, duress, or harassment. So Mr. Morse, he had a lot of this: intrusion, coercion, duress, and harassment. He continued to send out these mailers. He used the insignia of the government to try to get them to open these mailings. He didn't identify them as advertising, that's for sure. And he was basically threatening horrible consequences. So he misrepresented the nature of the services he was offering. So he hit a lot of different violations of what would be 7.3 now, and previously 1-400, which is what he was prosecuted under. Now, under subpart C, every written, recorded, or electronic communication from a lawyer soliciting professional employment for a targeted person, someone that that may be in need of legal services, has to include the word advertisement. But here's the part that's important, and here's the relaxation. Unless it is apparent from the context that the communication is an advertisement. So you don't have to put advertisement on your newsletter. It's obvious. So if in the context of what you sent out, it's clearly an advertisement, you don't have to say it's an advertisement. And most of the time that's going to be true. And under 7.3, even notwithstanding those prohibitions, a lawyer can be in a prepaid or group legal services plan that does have in-person, live, or real-time electronic contact. But that means that those services have to be, those reach outs happen through the LRS, not directly from the lawyer. Now, solicitation and solicit under the rule refers to an oral or written targeted communication initiated on behalf of the lawyer directed to a specific person that offers to provide legal services. So it has to be targeted. That's the difference between an advertisement and a solicitation, which frankly, with the way this technology is going, is getting very, very harder and harder to distinguish, because you're able to so closely target advertising now, it's almost becoming a solicitation. But again, here's a great place, read those comments, they help a lot. A lawyer's communication doesn't constitute a solicitation if it's directed to the general public, like a billboard. So even if you have the billboard right outside of Northridge Hospital and you are trying to target like the accident victims, that doesn't make it a solicitation. It's still an advertisement. And subpart A only deals with when the primary purpose of the communication was pecuniary gain. So it doesn't apply when other motives are at play. So it doesn't prohibit a lawyer from participating in constitutionally protected activities of a bona fide public or charitable legal service organization, or a political, social, civic, fraternal, employee, or trade organization for purposes of providing or recommending legal services. So if the purpose of the communication is not for pecuniary gain primarily, it doesn't, the prohibition against in-person, live telephone, or real-time electronic contact goes by the wayside. So, and also 7.3 does not prohibit a lawyer from contacting representatives of organizations or groups that may be interested in establishing a group or a prepaid legal plan. And those that participate in the services plan are permitted to be a part of that cooperative advertising, so long as it complies with Rule 7.1, it's not false and misleading, 7.2 as an advertisement, and 7.3b. Now, under Business and Professions Code 6152, this is the prohibition against running and capping, which is acting for consideration as an agent for a lawyer or law firm in the solicitation or procurement of business for the lawyer. You cannot just give out business cards to a mechanic and to give you, clients, like with the idea, oh, if I get so many clients from your office or your auto body shop, I'll pay you so much money. That is capping. What about a multi-claimant accident? Attorneys contacting other claimants for legitimate investigative purposes are not barred from representing them if they're requested to do so. But it's misconduct to directly solicit that employment. So if you are investigating because you signed up one client and you're looking for witnesses, and in the context of those interviews, you may pick up additional clients, that's fine. In the employment case, let's imagine you have a couple employees that have a wage and hour case, and now you're doing investigation to find other similarly situated witnesses who can vouch for what happened to your client. Maybe those could become potential clients, but you have to be very careful to document that those outreach were for the legitimate purpose of investigation and not for direct solicitation of new clients. Now, under Rule 5.1, you have supervising authority and responsibilities. So you cannot just have your staff violate the solicitation rules and be okay. You have to be monitoring to make sure that the advertising and solicitation activities of your firm are appropriate and follow the rules. Now, you also should be careful about, hey, we have to be careful not to be communicating with represented persons. So there's going to be a lot of lawyers going after those same set of prospective clients. Some of them may have already signed up with, retainers with lawyers. Be careful about soliciting people that already have found their lawyer. And then comment 4 permits communications on matters outside the representation. And comment 5 permits a lawyer to initiate contact seeking advice from an independent lawyer. So it is literally not improper for a lawyer to offer second opinions. You can do that. Clients are entitled to seek second opinions. That is not improper advertising or solicitation. Now, under rules 4.3, in communicating with a client who's not represented, you cannot state or imply that you're disinterested. When you know that the unrepresented person incorrectly believes you're disinterested, you have to make sure to take reasonable efforts to correct that misunderstanding. And if you know that their interests are in conflict with the interests of your client, you can't give them any legal advice, except you can tell them, go get a lawyer. And that would probably be the best thing you do in that situation. Also, in communicating with an unrepresented person, you cannot seek to obtain privileged or otherwise confidential information that you know that they're not allowed to reveal without violating a duty to another, or which you know that you're not otherwise entitled to receive, and that you're kind of getting it from them because they don't have a counsel to protect them. Now, under 7.4, this is the rule about communications about your practice area. You cannot state you're a certified specialist unless you have a current certified specialization certificate. And the relaxation in this rule is that there's only 19 areas of that are certified specialists under the state bar. But you can still say in another area, I specialize in this or that. As long as it's true, I focus my practice in this or that area, as long as it's true. You just can't say specialist or certified specialist unless you have that certification that's active. And you also can say what areas of law you do practice and you don't practice. And basically, yeah, like I already said, you have to have that current certificate to say you're a certified specialist. In the context of solicitation and advertising, it's always good to touch on fee sharing. Under 1.5.1, you can share fees with a lawyer, never with a non-lawyer. But with a non-lawyer that sends you valuable business, certainly it's okay to send gifts. So with that, I think we're just about done. And if there are any questions, let me take a look and hit a couple questions. Let me see if I can read it. This is the question. It says, under 1.5.1 of the rules of professional conduct, what if an attorney within the same firm refers or rather originates a case and brings it to the same firm, and that attorney receives a percentage of the recovery? Is that subject to the same rule to inform the client at the time of referral, or is it treated differently? Okay, great question. Rule 1.5.1 is necessary. You need a fee sharing agreement for lawyers outside of your firm. And yes, 30 years ago, there were only certain ways to be part of a firm. You were either an associate with a W-2 or you were a partner. But in today's world, there's a lot of different connections that you can have with a law firm to be regular, not just a W-2 person. But especially if you're a W-2 employee of a firm as either a non-equity partner or a associate, you don't have to disclose origination incentives to the client. You do not need to do that. The only time you have to have permission and client consent is when it's an attorney, a lawyer, or law firm outside of your law firm. So if it's someone inside of your law firm, you can say, many law firms have a bonus structure where like they have a base salary and then the lawyers get a bonus or additional compensation based on either a percentage of the cases they originate or a percentage of the cases that they settle. Both of those are totally fine, and that's private. That's within the firm. So no, the answer to that, sorry, long answer for no, you don't need it. That's what I would say. So with that, I think we're over time and we answered all your questions, or the ones that were there. If you still have questions, please reach out to me. It's Yes, and if you want more information, Annie's hotline is fantastic. Also, I'm sure she'd be happy to talk to you about all the advertising questions and solicitation issues you might have. But you can always shoot me an email, Erin at erinjoycelaw.com, about anything that kind of spurs your fancy with respect to this presentation, and I'm happy to field your questions. And with that, thank you very much. Oh, you know
Erin,
what?
that was a wonderful presentation. Thank you.
Thank you.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.